Welcome to Court of Protection Briefs. In this video, we're looking at the principles of the Mental Capacity Act 2005. These are the solid core of the Act, the court, its rules and code of conduct, the foundation to all of it. They are the commandments. In this case, 5, so fewer to remember, chiselled in stone and held aloft. Maybe they should be on the wall every time a court of protection sits. Principle 1. A person must be assumed to have capacity unless it is established that they lack capacity. Think about it. If it were you whose capacity was being questioned, wouldn't you want that to be the first principle? Principle 2. A person is not to be treated as unable to make a decision unless all practical steps to help have been taken without success. This is one of those areas that illustrate that problems with decisions in the court of protection can actually be a different aspect of what everyone faces. Not many of us are equipped to make decisions about, say, a work pension. To support us make the best decision, we have magazines, videos, our employers and financial advisors. It's just that with limited or declining faculties, people might need more support with decisions we may regard as obvious or commonplace. But with the right support, they can still make those decisions. Principle 3. A person is not to be treated as unable to make a decision merely because they make an unwise decision. The court is not there to make the decision it thinks would be best for you. It's there to make the decision it considers you would have done had you had capacity. Everyone who has capacity makes decisions others think are really dumb, or in the word of the Act, unwise. But part of being human and having capacity is being able to make whatever decision we want, even if it seems ridiculous to others. Principle 4. An act done or decision made under this Act or on behalf of a person who lacks capacity must be done or made in his best interests. And what is best interests? It's not what a judge thinks is best for them. It's more complicated than that, more in other videos. Principle 5. Before the act is done or the decision is made, regard must be had to whether the purpose for which it is needed can be as effectively achieved in a way that is less restrictive of the person's rights and freedom of action. Say someone who doesn't have capacity isn't eating and the court decides they should retrieve nutrition. By the way, they don't always decide that, not at all, but this time they do. There may be various ways that can be achieved and all will have their drawbacks, but under this principle, forcing food into them would not be the preferred option if they can get nutrition through a drip, for example. That's a wholly imaginary example. It doesn't properly present real clinical approaches. So there you are, the 5 principles, the shouts and the shout-nots. Presumption of capacity, all steps to support a decision, unwise decisions are okay, decisions in P's best interests, and least restrictive option. That's it for this video on the principles of the Mental Capacity Act 2005. Subscribe or watch out for the next video from Court of Protection Briefs.